E ku iluna, please rise. Au hea o ko e ko ka aha. Ina he kule ana, I mua o ki ia aha ho o kolo kolo ki e hano hano o ka moku aina o Hawaii, e nau e mai, e maliu mai, I lohe ia ka leo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii draw nigh. Give your attention and you shall be heard. E noho ilalo, please be seated.
Please call the case.
Case number SCAP-22-0000601, Unite Here Local 5, Plaintiff Appellant versus PACREP, LLC, and the City and County of Honolulu, a municipal corporation, defendants appellees. Arguing for Plaintiff Appellant, Unite Here Local 5, Gregory Kugel, also appearing Clint Hamada. Arguing for Defendant Appellee, PACREP, LLC, Sharon Lovejoy, also appearing Miley Miller, and arguing for Defendant Appellee, City and County of Honolulu, Brad Saito. Argument on the merits.
All right, good morning, aloha everyone. Our proceeding today is being broadcast live on our YouTube channel as well as on Olelo. Counsel, are you all ready to proceed? All right. All right, we've allocated 30 minutes for each side. Mr. Kugel, 20 minutes, and you reserved 10 for rebuttal, so we'll give you a warning with 10 minutes to go. Ms. Lovejoy, Mr. Saito, 15 minutes each, and we'll give you a warning when you're 5 minutes left in your allotted time. Mr. Kugel, please proceed.
Thank you, and good morning, Chief Justice Rechtenwald, Justices McKenna, Edens, Ginoza, and Devens. May it please the court, my name is Greg Kugel, and I represent the plaintiff appellant in these cases, Unite Here Local 5. The last time that these parties were before this court, the same parties, the same project, the same attorneys, was in 2019 when this court decided Unite Here Local 5 versus Department of Planning and Permitting. That's 145 Hawaii 453. In that case, this court held that Local 5's procedural due process rights were violated because of a secret agreement between the Department of Planning and Permitting and PACREP that waived certain Waikiki Special District, or WSD, permit requirements that were put in place by DPP to satisfy mitigation concerns raised by Local 5 in that permitting process. That case 5 years ago was the proverbial cart before the horse. It was the cart because it dealt with the permits. But in Waikiki, for development in the Waikiki Special District, Chapter 343-5A5 has a trigger that says that when there is going to be development in the Waikiki Special District, a environmental assessment or environmental impact statement has to be prepared. This is that horse before the cart, which the court already decided. Today I intend to cover three broad topics, which I hope will answer questions which I know you have. Those topics will be, in general, HEPA and segmentation under HEPA, which is Hawaii's Environmental Protection Act, Chapter 343. Secondly is mootness and remedies that are available under HEPA. And then third, if time permits, I will explain why these two narrow and intentionally constricted environmental assessments that were presented to the city for the two phases of this unified project was not the functional equivalent of a proper environmental impact statement required under Chapter 343 that would have evaluated the project as a whole. Let me talk again just generally about evidence of segmentation. This court just unanimously decided in 2022 the case of Kia'i versus Kauai Department of Water, in which case this court considered the question of segmentation of HEPA and when a project as a whole must be looked at. In that case, it was a water line that was being sized on Kauai to serve not just existing needs for water, but also potentially future development for Lehui, among other projects. This court reversed summary judgment that was granted for the county in that case and remanded to the circuit court to consider evidence of segmentation. I think this court found in that opinion that there was an inference of segmentation based on the undisputed fact that this was an oversized water line that would address future development needs for Lehui, but it remanded to allow the plaintiff to produce evidence before the circuit court of actual segmentation. This case is a beautiful follow-up to that case because here we have actual evidence of segmentation. We have not one, but 4 smoking guns, which I will cover in my remarks. And those were,
Counsel, speaking of cases, has this court ever considered a case seeking to invalidate an EA or an EIS after the permits, after the project's been completed, and one more thing, after the project's been sold to third parties?
it has not, Your Honor. And that's why I intend in the second part of my argument to encourage you to adopt the well-reasoned Ninth Circuit and other courts of appeal cases interpreting NEPA, which is the federal predecessor to our own HEPA. Those courts have dealt with that exact question.
So let me ask you this, and I know I'm sort of moving to your second point about possible remedies, but let's say there was improper segmentation, and I'm just wondering how we grant you relief when the developer here no longer controls the project.
That's a good question, Your Honor. I was going to cover it later, but I'll cover it now, and that is the Ninth Circuit has said in 3 cases, Cantrell, West versus Secretary of Department of Transportation, and Columbia River Basin, it addressed that exact situation. And
what are the citations for these cases?
oh, thank you, Your Honor. Sorry, I've got to get ahead of my notes here. Cantrell is perhaps the most important one. That is 241 F. 3rd 674, a 2001 case in which the Ninth Circuit said, addressing the very question Your Honor asked me, quote, when evaluating mootness in NEPA cases, we have repeatedly emphasized that if the completion of the action challenged under NEPA is sufficient to render a case non-justiciable, entities could merely ignore the requirements of NEPA, build its structures before a case gets to court, and then hide behind the mootness doctrine. Such a result is not acceptable. It's not acceptable in the Ninth Circuit.
I understand that's what the cases say. What remedy do you seek now that could still meaningfully be provided by this court?
Thank you. The other 2 citations, Justice McKenna, West versus Secretary of DOT 206 F. 3rd 920, Columbia Basin 643 F. 2nd 585. Those were mentioned, I believe, in our opening and certainly in our answering briefs. In terms of the remedy, the Ninth Circuit has said, it has said in the Cantrell case, we cannot order rebuilding of the destroyed historic buildings or destroyed wildlife habitat that had already occurred before NEPA review. But they did say, upon further review, the agency could implement further mitigation efforts to offset environmental impacts. The Ninth Circuit, in the 2 other cases I mentioned, West and Columbia Basin, went further, and they said it is within the power of the district court to order destruction of the improvements that have occurred or lesser alternatives to address mitigation, such as, and they said it in the West case, use restrictions or structural changes.
So what remedy are you looking for at the end of the day if this should be sent back down?
Thank you.
Tear down?
I was going to say the answer to that is no. And let me give you the short answer. This court, over decades, has addressed a very similar situation when you have, in the law of restrictive covenants. This court said for the first time in Sandstrom v. Larson, said if you have a violation of a restrictive covenant, a mandatory injunction or tear down order is appropriate. Then you have the flip side, which is the Pelosi versus Wailea Ranch cases, where the Intermediate Court of Appeals said, when you have the situation where there was a violation of a restrictive covenant, but the properties have been transferred to innocent third parties, then a court must balance the equities to fashion the appropriate relief. And ultimately, Justice Devins, you have the Kia'i-Vai case in which this court both not only remanded for consideration of segmentation, but most importantly, for consideration of injunctive relief. That's the very last sentence.
Yeah, I did want to ask you about that. Did you seek injunctive relief in the circuit court while this building or buildings were going up?
We prayed for it in our complaints. There were two
Right,
complaints.
but you didn't
Your Honor.
file a motion.
We did not move for a motion. I can certainly explain the timing of this case and why that couldn't happen. But it's also not the rule in the Ninth Circuit or under NEPA.
I understand, but we are crafting our own rule. Why would we not take into consideration the fact that you had a possible remedy that could have avoided us getting in a situation where we have the building already built and a certificate of occupancy issued? Now,
Thank you, Chief Justice. There are several reasons. First off, I think that makes bad policy and bad law. Secondly, if you look at the way HEPA is structured, there is a very short statute of limitations, 30 days to file a lawsuit. The plaintiffs, like in this case, could look at these two AAs like anybody else can do and like you will do and say, these are two phases of a larger project, clearly. So it's apparent on its face, but that's not the evidence that this court wanted in Kia'ivai, for instance, of segmentation. And until this court's decision in Kila Kila 1, which was the Maui telescope case, where the court considered not the substance of the environmental impact statement issues, but rather the procedure. And this court held for the first time that because this is a Chapter 632 proceeding, discovery is available. We sought to do discovery in this case commencing in 2014. That discovery was denied on a motion to compel based on the ICA's decision in Kila Kila that got reversed. Well, when this court then said no discovery is available in Kila Kila 2 in October of 2016, we then went back to the circuit court, moved to compel. In 2017, in the summer of 2017, the court granted the motion to compel. We finally got the discovery, which comprises the documents that show the smoking guns that I'm talking about today. So
Without the discovery, did you have enough for a preliminary injunction at least to file for one? Without the discovery?
I could file for one on bare allegations, Your Honor, but under the injunctive test that I know fairly well, I don't think I could show likely to prevail on the merits. Maybe certainly I could show irreparable harm if they allowed it to go. The courts balance those. I can't tell you how it will come out, but it could have been denied on the bare allegations of the
But in your case, you felt you needed additional discovery.
I did.
And that was denied in the,
I
on the
did.
front end.
But, you know, one, it seems that, you know, your first remarks were suggesting that somehow your complaint sufficed. I mean, as I look at Rule 65, it's a notice provision, among other things, and you have to provide notice when you're seeking an injunction. So there's that. But more importantly, you know, between the final EA and the completion of the project, there seems to have been a years-long time frame in which you could have filed a 65 motion. And is what I'm hearing is just that discovery hadn't shook out, and that's the reason why you didn't?
That's the primary reason, Your Honor. I think we needed the evidence of segmentation, which the case on its face demonstrated to anybody. Do I think I complied with Rule 11 in filing the complaints? Absolutely.
Mr. Kuko, can you clarify when you received the discovery?
It began in after the summer of 2017 and proceeded into 2018. It was rolling and it was late. And I think for the court's benefit, it would also help you to focus on when PACREP received its temporary certificates of occupancy for these two structures. For phase 1, which is 2121 Kuhio, its temporary certificate of occupancy was issued January 9, 2016. What that means was by that date, the structure was sufficient for its intended purpose, substantially complete, but not a final COI from the city. Tower number 2, 2139 Kuhio, received its temporary certificate of occupancy July 13, 2018. So in other words, at the time we are getting this discovery, these buildings are up and they're getting temporary certificates of occupancy from the Department of Planning and Permitting to use the structure.
When did you, I think you said there were 4 smoking guns. When did you actually get that information?
Your Honor, I do not recall the precise date that that discovery was presented between the date in August of 2017 when the circuit court ordered that they comply with the discovery requests and the date it was actually produced. It was sometime after August of 2017, and there were rolling productions, and it could well have been at the end of 17. It could have been in 18. I don't recall that fact, Your Honor. Sorry.
Thank you.
But you don't believe you could have sought a preliminary injunction just based on the timing of the two projects, one being initiated shortly after the EA for the first was accepted, and also, you know, there's sort of, I believe there's some references in the EAs, you know, the part of the podium jutting out into the 2139. You don't think that was enough to come in and say, we need to put a stop to this while we get the discovery we deserve, or?
Well, at that time, the controlling law from the appellate courts was the ICA opinion in Kila Kila, and that was also the prevailing wisdom at the circuit courts. You don't get discovery in a Chapter 343 HEPA declaratory judgment case because it's like a Chapter 91 administrative appeal, which is confined to the record. That's in fact what the defendants argued to the circuit court the first time we saw it discovery in 2015, and we were denied. And it wasn't until the Supreme Court reversed the ICA in October of 2016 and said, no, Chapter 632 is not the same as Chapter 9114. And that makes sense. What the agency knew and what the developer knew are not going to be in the record. If you had smoking guns of segmentation from the developer in 2011 for this project, is it going to tell the city before it applies for its first EA on what intends to split up among two EAs that it in fact intends to develop the second one? Of course not. That's why it said 4 times that keep that second project secret from our consultants and from the city until we get the permits.
Are one of these smoking guns this confidentiality agreement, I think from around 2011 with respect to the food pantry?
That's not a smoking gun. That's something else we got in discovery. That shows that in 2011, long before they applied for the first EA, they were contemplating buying 2139, and they were in negotiations at the same time to buy 2121 Cujillo. 2 different sellers, so they proceeded on different tracks, but they were planning a joint development as early as 2011 when they were in negotiations for both properties.
Does it make a difference that they never came into ownership of the food pantry lot until I think it was March of 2013?
I don't think it makes a difference here. All that is implementation of their plan to segment. Their consultants told them they were segmenting. They knew they were segmenting, and that was a way of delaying actual ownership despite negotiating for it for at least 3 years until after EA number 1 was approved and WSD permit number 1 was approved.
Along those lines, what discovery, if any, did you obtain regarding negotiations for the food pantry lot from the date of the confidentiality agreement to March of 2013?
Well, we also obtained their first offer on the food pantry lot, which was in November of 2011, and that's also in the record. I'm sorry, Your Honor,
And as of February of 2012, food pantry was responding that PACREP was starting to push on 2139 as of February of 2012, and apparently food pantry responded that they were having their financial analyst analyze the value of the premises that was being offered, or the reduced lease for a new food pantry site.
That's correct, Your Honor. It was.
But there's nothing between February of 2012 and March of 2013 in terms of the continued negotiations, in terms of discovery?
Your Honor, not that we obtained. I think, and to be frank, I didn't depose PACREP or food pantry's principals to find out when they concluded the negotiations, what we received in discovery in terms of the documents, or the eventual lease with a option to purchase, and then 2 weeks later they executed the option to purchase in 2014. That's the state of the record that we have.
All right. In terms of the
would say-
remedies that you're seeking, I have a
Sure.
kind of more fundamental question. The developers were PACREP 1 and PACREP 2. Are those entities still in existence?
When we were at the circuit court, they were, to my knowledge, neither has filed any pleading in this case saying they've been dissolved.
What business form are those organizations?
They are limited liability corporations, foreign limited liability corporations, I believe, Your Honor. The fact that they are both filing briefs in the proceedings before you leads me to conclude that they still exist as entities.
Right?
Let me go back to the remedies that you're seeking. You alluded to parks and parking. Can you give us a sense of what this might look like if we were to remand for, I guess, an EIS to be done? What the outcome might be that you would seek?
Yes, I believe that the circuit court or the Department of Planning and Permitting can impose additional mitigation measures to offset the environmental impacts we allege. Now, keep in mind, this is the center of Waikiki. We're not talking about the environmental impacts that this court considered at Turtle Bay over a decade ago that was endangered species and archaeological features and so on. This is Waikiki. The environmental impacts are different. They're off-street parking, their jobs, their views, their quality of life, their workforce housing. Those are the kind of environmental impacts that happen in Waikiki, which is fairly fully developed already. What I foresee, Your Honor, is there is this court's decision in Morgan versus Planning Commission, that's a County of Kauai Planning Commission case, where this court said that an SMA permit that was granted by a county could be reopened, reconsidered, and changed. Its conditions could be changed, particularly as was the case in that case where the developer did not build what he told the county he was going to build and what he got permission to build. He built a seawall, not a revetment. This court said you can go back at any time and change those conditions to fix the harm that's occurring. And that's what we suggest is certainly within the ability of the Department of Planning and Permitting here. In fact, if this court looks no further than our last appearance before you in the WSD permit case, when that whole fight was about mitigation conditions that were imposed on permit number 1 that would require hotel use of the units. It would require additional parking spaces if they were converted to residential units. The director of DPP, when he issued that permit publicly, said, I'm going to impose conditions on this permit that protect against the harms that Local 5 has identified. What we all know what happened, well, they made a secret deal and said, oh, let's waive those conditions, not just in permit 1, but let's not impose them in permit number 2.
Did you have any evidence that the eventual sale of the food pantry lot was deliberately delayed for any reason?
I have nothing other than the date that PACREP tells us that it closed, which was in 2014.
But there's certainly pretty substantive discussions going on between the parties about developing it as one project, at least from what I saw on the record that was submitted.
There are a huge number of documents for PACREP and its own consultants internally saying, develop these as phase 1 and phase 2 of a joint project and don't tell anybody, and going through iterations of schematic designs on both properties even before the EA went in on phase number 1. So they clearly contemplated the possibility of joint development. In fact, they look at that as a scenario that eventually—
Well, they were actually talking about merging the two projects, right? They think the merger is easy. These are in emails that were submitted. The
Correct.
bridge over with the parking, use the podium, they use the term podium, but it seems to be a pretty significant structure.
That's the
8
shared
stories.
8-story podium that had more parking than will be required for phase 1, but had the exact amount that would have been necessary for phase 1 plus phase 2. The exact same shared
As a
podium.
hotel,
I'm sorry?
as a hotel, parking.
Parking as a hotel,
Right.
correct, Your
So
Honor.
one of the issues is the way the project has been structured now, there's no requirement that it be used as a hotel, correct?
That's correct.
Is there anything in the record to indicate how many of these total units are now in the hotel pool, or what percentage are actually in the hotel pool?
Not as of now. The only thing that's in the record, Your Honor, was the projection by PACREP itself in both of its EAs, where they said, our experience based on our prior project at the Trump Tower in Waikiki, there's about 5% of unit owners that will use these as
I
permanent
thought they said more like
residents.
10 to 12%, but then up to 25% at some point.
Your Honor, I think there were a variety of numbers. They identified 14. They said there'd probably be statistically about 14 out of 400 units in Tower 1.
This is not called the Ritz-Carlton Hotel. It's called the Ritz-Carlton Residences.
That's right, Your Honor. It is, and they were sold as two. PACREP's own documents, again cited in our opening brief, described their access to the Asian markets, where they would sell $15 million penthouses, which is why they needed the extra height on these towers, and they needed the Diamond Head Eva orientation to capture ocean views to sell these. They said you can live in them, you can use them when you come, you could put them in a pool that we manage, you can manage them on your own as transient. And that was the problem with the initial permit.
Is there anything in the condominium documents or in the association bylaws that require units to be within a hotel pool?
Not that I'm aware of, Your Honor. No requirement no private requirement that they be in a hotel pool.
So real quick, going back to the initial process before DPP on the 2121 project, there's many references to 2139. The address for the property is referenced as including 2139. I'd like you to just speak about that. I mean, you've talked about this, the secrecy and the keeping confidential, the negotiations, et cetera, going on. There was clear reference to 2139 in the county documents.
I believe that reference that you're speaking about was the fact that even as originally contemplated with this overly sized podium, it was going to cross from the K3 lot, which was 2121, onto the food pantry lot by 8 feet. And so because that's joint development over a property line, they included that address as well.
But so that does show, as Justice Ganoza is indicating, that you had, even based on the documents that were available from the city before you got the discovery in 2017, it was pretty clear that this was a joint development.
What was clear at that point, Your Honor, was it was a joint development in the sense that a large podium would encroach slightly
And why would that not have been enough to file for a motion for TRO or preliminary injunction?
Because there was no indication that they were going to come in a year later with an EA for a second tower that sat squarely on the spare space on the podium. That's why. We didn't know it until they came in with the EA. That was the public acknowledgement or recognition that there was going to be Tower 2 placed on this shared podium.
Let's look at it a different way. I mean, without ownership of 2139, I mean, could they really have filed along the lines that you're suggesting?
My understanding, they would at least need the consent of the record owner that permission to affect its property was being sought with that.
And to some degree, then we kind of need to know where they were along the lines in the negotiation for the purchase of food pantry. I mean, isn't that a fair statement?
It is, Your Honor, and I think it would be interesting to watch the evolution and to get more of the documents than we are already privy to. I don't think it's necessary. I think that the circuit court before it on the summary judgment motion, it had the 4 smoking gun emails I mentioned that said keep it secret. It had PACREP's own statement that the city does not like bait and switch. It had the statements from the consultants saying when they floated the idea of environmental assessment number 2 for phase 2, Keith Kurohashi, G70, and PBR Hawaii all had reservations about segmentation under HEPA. And that's why two of those.
But you
cases-
didn't have all that information in time to file your preliminary injunction, though. That's the position you're taking, right?
We did not have that as these
If you
towers.
had it, you would have filed it?
Yes, we did not have that as these towers were going up.
You know, there was one email that was dated, I think it was January 30th, 2012, and there's discussion where they're saying, debate as to whether we submit one EA application for both sites, even before a deal is reached with the owners of FP. DPP looks favorably upon full disclosure if we intend to potentially joint develop the two parcels. Do you remember when you got that specific email? And I'm sorry that I pulled it out of a bunch, but if you remember.
Yes, that would have been after the circuit court granted the motion to compel after August of 2017, when we finally began to get documents.
In
The exact-
2017.
I'm sorry,
You said that was in 2017.
yes, August of 2017.
Thank you.
What happened between 17 and 18 and 22? There was like a 4-year hiatus in this case. And you also said you didn't depose the principals of PACREP. Well, what was a hiatus and why didn't you pursue discovery at that point through depositions?
Thank you. And again, Your Honor's testing my memory, which is the reason why my associate said I have to argue this, not you, because I lived through it, so I do have some memory. I believe the parties had recognized, as this court's precedent says, in EA, EIS, HEPA cases, they're decided on summary judgment. There were drafts of summary judgment motions filed before the circuit court on all sides, seeking a comprehensive. Obviously, we wanted a different result than they did. When discovery was allowed after 2017, additional briefing was done after documents were obtained to supplement the record so that the case, which by that time had transferred from Judge Nishimura to Judge Ashford, could be decided with evidence to support our motion for summary judgment. And so Judge Ashford ruled, and again, the exact date escapes me, but it was in this decade that he granted their summary judgments, denied ours, and we took the appeal. I would add what was also happening was we were briefing and then arguing in 2019 the WSD permit cases for this project before this court.
You indicated that in the way things are working, circuit court, now environmental court, there was a working understanding before this court's ruling in Kila Kila in October of 2016 that discovery was not allowed, that EA or EIS cases were decided based on the administrative record. Does there seem to be a working understanding also that based on some of this court's prior cases that the remedy for a failure to properly go through the Chapter 343 EA or EIS analysis, and then a project is then completed, that the only remedy available is for the permits to be set aside and the project to be taken down?
Your Honor, I don't think in Hawaii there's a HEPA case that I know of where a project was ordered to be taken down. I also don't know of one that considered these facts as well, which is why I point you to Ninth Circuit and NEPA. What we do know from the Kepo'o versus Connie case, which is, there were two cases. It was the subsequent one, 106 Hawaii, I'm sorry, I forget the page number. But in Kepo'o versus Connie, the question was whether a lease that had been executed between a power plant developer and the Department of Hawaiian Homelands, where they had circumvented Chapter 343, what was the effect on that lease? And in that case, this court said that lease is void. If you don't comply with HEPA, HEPA has strict requirements. If you don't comply, then the consequence is void, and they voided the lease. There were arguments in that case that this court rejected that said, wait a minute, a lease is a property interest. We have a right to the property inked by a lease. And this court said, not based on circumventing HEPA. This court went further and said, you don't have a property interest and you don't have a vested right, and you don't have a takings claim because you didn't comply with HEPA, which is a condition precedent to getting approvals for a project when HEPA requires it.
This case, the property has now been sold to third parties, though. Quite a different situation, right?
Your Honor, my recollection is they said most of the units, not all of the units. I know that when we were before the circuit court, I believe they retained some penthouse units. I believe they also might have had developers' rights under their documents to impose conditions notwithstanding that an association of unit owners had been created. But I frankly don't know the status today. Kepo'o versus Kane, you're right. That involved the developer and the agency and no third party. Again, I would point you, again, it's not a perfect analogy, but Pelosi versus Wailea states where the Intermediate Court of Appeals had to consider the question of there was a bad guy who violated land use requirements. In that case, it was a restrictive covenant. He sold, and now you have innocent purchasers for value who are being asked to bear the cost of mitigating or correcting the restrictive covenant violation. And the court said you have to balance the equities. I think, again, balancing equities is what I say this court can do. This court can find there was evidence of segmentation. The circuit court was wrong to rule on summary judgment there was not. And I think this court can hold as a matter of law there was segmentation, remand it to the circuit court for consideration of remedies. If it's a court of equity, I think the court has to consider things, including whether Local 5 waited or whether that waiting was justified in seeking a preliminary injunction or not, and what consequence that has on the relief to be granted. I think weighing the equities, as Pelosi versus Wailea Ranch says you should do in a different context, requires considering the rights of third-party purchasers, considering the culpability of the defendant, and so forth. So that, fortunately, and if you read Kia'i Vai, is what this court just did, send it back to the circuit court to consider remedies.
All right, Mr. Kugel, we've gone over by a bit, but I will give you some rebuttal time after we've heard from the other
Thank
side.
you.
Thank you.
Thank you, Court.
Ms. Lovejoy, your argument.
May it please the court. Basically, the issue here is primarily an issue of were these projects properly reviewed under HEPA? And corollaries to that are the segmentation, and a corollary to that as well is the mootness issue. Here, there are extensive environmental reviews, as Judge Ashford found. This is not a situation where PACREP submitted environmental review documents to the DPP, they rubber stamped them, and they said, good to go, let's move forward. Remembering that the environmental review process and the environmental assessment documents design is to inform decision makers. There are a lot of assumptions that are being made by counsel for Local 5. The 4 smoking guns that he's alleging, I don't see them as smoking guns at all. What I see them as is the process of a developer. The process of a developer is to say, what if? What could we do? What might we do? An environmental review has to be done at the earliest possible time. If PACREP were to have not proceeded on its environmental review and move forward, we would be here on a situation where Local 5 likely would be saying, you know what? You violated because you didn't move at the earliest possible time to go forward. The issue of what might happen, can we cut a deal with food pantry? Clearly, they worked on that for a long time. It's very obvious from the documents that 2121 project was moving forward no matter what was happening. It's its own independent building, it's its own independent project, and could be built as such. And the only thing that attaches it to the other building is the podium. That's what Judge Ashford found when he thoroughly reviewed all of the documents that were in front of him. There's the issue that was raised about.
I'm sorry, when you say it's only a podium, isn't it an 8-story structure?
Yes, but it's a podium. It's not the 400-foot podium. I mean, it's not the 400-foot structure.
And what's in this podium? What is it used for?
Sure, it's parking, and then it has it's primarily parking, but then it has some outdoor amenities.
And it serves both properties?
It can serve both properties.
And that's what it was intended for?
That's how it was
first built?
revised in the 2031. Once 2031 came into place, they required a redesign of what was approved in the FEA for 2021. And the DPP required, go forward and look at this, study that, and what have you, in order to look at the environmental consequences of all of this. So it actually required a redesign of 2021.
But when it was initially designed and built, it was already encroaching into the food pantry lot, was it not?
No, when it was initially designed.
And built.
Oh, no. Well, ultimately, it wasn't built before all of the 2039 went forward, but the encroachment, that happens all the time. It's a joint development agreement. It includes the entire block, and it includes property that the PACREP entities don't even control. And the joint development agreement was done before PACREP ever owned any interest in any of this property. That joint development agreement was done in connection with prior owners' plans to build. It was entered into in the year 2000.
In this one email that I had asked Mr. Kugel about, it says DPP looks favorably upon full disclosure if we intend to potentially joint develop the two parcels. Why wasn't full disclosure just simply done if that was the belief?
But the next line, Your Honor, if you read the next line, it said, so I need to push food pantry harder. I need to make sure, see what we're going to do here. Because.
Right, but it's speaking in terms of potential joint development.
Let me give Your Honor an example. Recently before this court was the Howard Hughes case involving the rail development through Ward Village. As part of that case, there was extensive discovery done. In that discovery, and in some of the briefing to Your Honors, there are all kinds of what ifs. There are buildings all over Ward Village that don't exist now, may never exist, might exist in the future in some form or fashion, but the developer's saying, what if? And what they're doing the what if about in that case is, what if TOD is passed in Kaka'ako? What can we do with our property? That's a developer's process. The developer says, what could we do with this property?
But why say, don't tell our consultant, don't tell Keith? I forget the exact words. Don't tell Keith.
Sure.
Why would you say that?
Keith is local on the ground here. From a developer standpoint, they were in touchy negotiations trying to get food pantry to sell them that lot. They said, don't, in other emails, they said, don't put it outside of this small group, right?
Because Keith had said from the beginning that if there was going to be major changes like adding 2139, it would have to be together, right?
He said there would be an issue of segmentation.
Right. So along those lines, Mr. Kurahashi was originally with Towel when he was initially retained. Was he ever with Towel? He was never
not
with Towel. Okay.
Keith Kurahashi was on his own.
He was always on his own, and then you were telling him, internally your people were saying, don't tell him. And then when you decided to pursue, go forward with an EA for 2139, he basically said, I'm not doing it. Several others said, I'm not doing it. And then you decided, then the internal email says, let's go to David Tanoe of Towel, who had been the DPP director overseeing the initial EA, correct?
Yes.
And then, but for some reason, it's not Mr. Tanoe at Towel, it's somebody else in Towel that submits the EA for 2139?
They hired the company, Your Honor, who signed
Oh,
it.
so
I
they
don't
did.
know.
So they did hire Mr. Tanoe, who had been overseeing the EA for the original
I am not
2121?
sure, honestly. I think the timing probably lines up, but a lot of people are using Mr. Tanoy because he went out and owned his own business and he knew the rules inside and out and how to come at it. I will tell you, it's not in the record. It may be a big assumption to say that Mr. Kurahashi wouldn't do it because of a segmentation issue. There's nothing in the record on that. My recollection is there were some other health issues that he was dealing with, but it's not in the record and I don't think.
But
we
there
need to
was
go into-
somebody else that was also contacted that expressed serious concerns regarding segmentation and this being a small town.
He did, but ultimately said, I don't, if you read the rest of that email, he says, I don't have the time to do it. And he raised the issue or concern. The client here basically is also recognizing the issue, but is saying, it's chicken and egg, right? We don't go forward with an EA until we know we control the land, we control the property.
But isn't this at least a question of fact? Wouldn't there be, hasn't the Local 5 at least put in enough evidence to raise a question of fact as to whether this project had proceeded to the point where this was in fact an effort at segmentation?
Two issues to raise there. First of all, Local 5 stated on the record, and to Judge Ashford, that they do not think this is an issue of fact, that this is something that should and could be decided as a matter of law. And the second point is, the environmental laws are a matter of disclosure. I don't know of any case that says it's a matter of intent. Even if you were to say, maybe that was their intent, the intent is what was disclosed. And these were very thorough, very exhaustive disclosures. And when the 2039 EA was being evaluated, the DPP probably, to my client's chagrin, because they would like to get it approved, they kept going back and say, nope, we need to consider 2021. How is this going to come into play? How are these going to work together? And actually, as a result of that iterative process, it resulted in redesign of some of the 2021, right? So the issue is disclosure.
So you're saying that after the 2139 DEA was submitted, 2121 was redesigned to conform with 2139?
Parts of it were based on concerns raised by DPP on how, so they were looking at how would these things fit together, right? They were looking at both projects. So if you were to say there was inadequate disclosure here, I would ask where? What's anticipated? There's nothing that Local 5 has raised that says, we think it's likely that there will be a significant environmental effect if a full EIS is done. And in fact, this court has previously said, you know what? If an EA is found to be insufficient, you go back and do a new EA. So with the extreme breadth of disclosure, and I would say in my experience, the 2139 FEA is much more akin to an EIS than an EA. What additional information really is anticipated to be disclosed?
Well, isn't there, the argument they're making is that the EAs were done separately and they should have done as a project as a whole to capture all the cumulative effects. Isn't that the argument that they're putting forward?
Well, they are making that argument, but 2139 does include all the cumulative effects. They haven't pointed to any cumulative effect it doesn't cover. So they are, and to say that if a developer is considering, hoping, praying, and planning for a next door development, that they then have to, at that point, go forward with an EA, would totally turn development on its head. There's a lot of confidentiality.
So are you saying the EAs that were done, evaluated the project as a whole, both lots? Is that what you're saying?
The 2139 evaluated the project as a whole. Obviously, 2121 did not, because 2139 hadn't been done, evaluated, planned, property purchased. But here, if you look at segmentation, the issue in Your Honor's recent case was the double independent utility test, right? So here we have two towers. They share a podium, but could they operate separately? They have independent electronics. They have independent mechanical. My understanding is that the electrical goes out in one, it doesn't go out in the other, because they were designed and built as separate properties. As they were going forward, they're like, hey, could we attach this? Let's do that. And because it was on a prior joint development agreement, the joint development agreement under the land use ordinance allows for joint development of those parcels. You just need cooperation from the adjoining landowner. That's why the encroachment isn't a problem.
So, but they're indicating that they didn't have discovery of the consent of the discovery materials don't seem to indicate when and how Food Pantry consented to the podium jutting into their, podium of 2121 going into their property. So when was that consent obtained?
My understanding, and of course they've never raised that as an issue, or have they ever said the discovery was deficient? My understanding is that was done back when it was being planned, that they got the food pantry owner to say, can we come over to this parcel? I do want to.
So they already had the okay from the food pantry lot to build into their lot.
To do
at
that.
the time they were doing the EA for 2121.
I couldn't tell you an exact date, but that's my
And
understanding.
it was an 8-story podium just kind of sticking into the property.
By a few feet,
Right.
yeah.
What's a few feet? Wasn't it like 7 feet?
It was either, I thought it was 3, somebody here said today 8, but it's given the size of these parcels, it is not much at all, right? So I do want to say equity must do equity.
Let me ask you, what's the current legal status of PACREP?
PACREP still exists. My co-counsel here just pulled it up. Apparently they are delayed on one of the Hawaii filings, but the entities still exist.
One
What's-
and two.
I believe, yes.
And what's your position whether, say this court says that there should be some sort of an environmental,
I'm sorry, I thought I silenced it.
say this court says, you know, that there should be a completed proper EA. What's your position as to whether PACREP can conduct mitigation?
PACREP has no control over the buildings anymore. PACREP has no, to me, this is, Local 5 is here trying to upend a process when they could have and should have, under this court's other cases that have, not in a HEPA case, but in other contexts, said, you know, you can't sit on your hands. They're here, he's saying equity would allow this. Well, equity has, somebody seeking equity has to do
So
it.
is your position PACREP's out, so, you know, you can't do anything at all as far as any type of mitigation?
I don't know that PACREP would have the ability to do any type of mitigation.
Can the owner sue PACREP if there are effects with respect to mitigation?
I don't know, but I would anticipate that that would be a big issue. I do want to say,
Mr. Kugel referred to some kind of developers agreement or developers rights or something like that. Is that in the record anywhere?
I don't know what he was referring to. I do want to say on this issue of what happens, the Ninth Circuit, and contrary to what Mr. Kugel has said, that the Ninth Circuit is all about mootness. All of those mootness cases, there was something else left to be done. Okay? If you look at a number of other cases in the Ninth Circuit, there are a lot of them that say cases are moot. When there's nothing left to be done, the case is moot. And in the context of NEPA environmental review. The other thing is, what they're really asking for is in the nature of a mandatory injunction. And this is after, and I 100% disagree with counsel, that they couldn't have sought a TRO and motion for preliminary injunction. Their opening brief argues that they knew about Tower 2 because of the Tower 1 building orientation alone. They argue in this argument, clearly, just looking at the FEAs, that these are two phases of the same project. Now they're saying, oh, we needed discovery. But we know that isn't true from the way they alleged their complaint in 2139. What they did is they sat on their hands. And if this court were to allow parties 10, 12 years later, after not pursuing their rights, after the project has been sold, all of those are public notices to say, you know what, we're still going to proceed here and now go back and change everything, and hundreds of new owners, right? The Ninth Circuit was overturned in the Monsanto case on a NEPA-related case. And in the Monsanto case, U.S. Supreme Court case, the court said that parties have to meet the injunctive relief requirements before you can just say that a violation of NEPA means an injunction. And in the Ninth Circuit case in Cottonwood Environmental 589 F3rd 1075 at 1089, the Ninth Circuit said, yes, the Monsanto Supreme Court told us we've been doing it wrong. That there isn't, the Monsanto court said, you don't get to put your thumb on the scale of injunctive relief just because it's a NEPA case. So then they balance the irreparable harm. That's a requirement. And in the case, which name escapes me, but you all will probably remember, I think it's the one involving the pipeline underneath the reservoir on the Indian lands that happened a couple of years ago. The DC Circuit said, yep, Monsanto, and kicked it back there for an injunctive relief determination. But here, what relief can happen?
You're about 5 minutes over, and I do want to give you a chance to wrap up before we hear from Mr. Saito.
Sure. There were a lot of issues that were raised, and I think if put in the context of how a development works and how it goes forward, there was no secret, there was no big deal. And when is the dividing line? If you have to move forward, if you might do a project, then all of the agencies are going to be flooded if developers will even go forward at all, because what a developer might do is sensitive. What somebody might do if they can acquire a property affects the value that you can get the property for, affects who else might try to go do that, affects any number of things. So all of these smoking guns are just the development process. And I urge your honors to consider that in looking at these, in addition to what really hasn't been looked at here. And Judge Ashford, in my experience, has been very thorough. I don't know what your honors' view has been, but he basically said this isn't a close call for him. Just for the number of factors, his transcript is very thorough on how he came at it.
He said if it were a regular summary judgment, there'd be a question of fact. But as you pointed out, Mr. Kugel said, we want to go ahead on the record we have. But applying rule of reason, deferring to the agency, then it wasn't close in his mind.
Absolutely, Your Honor. And if we were to open that door of summary judgment, then we could be of actually weighing standards and material facts, unlike our historical approaches to HEPA cases. Then the issue of preliminary injunction, TRO, it becomes even more significant and urgent because the case will go on for potentially, 18 months to 2 years longer.
Very well. Anything further for us at this time, Ms. Lovejoy?
No, thank you.
All right, thank you. We'll hear from Mr. Saito next.
Aloha mai kako, and may it please the court.
Mr. Saito.
What is the remedy for segmented EAs? This court addressed that question in part in its Kia'iwai opinion. It said the EA should be remanded for the preparation of a new EA. And the purpose of that remand would be to assess the secondary and cumulative effects of using more water, taking water from additional sources. In this case, that's not the type of situation that we have. First of all, DPP approved the EAs because they found them substantively adequate. Right? The EAs disclose secondary and cumulative effects. For example, noise impacts were described for Tower 1 alone, for Tower 2 alone, and Towers 1 and 2 together at different locations near and far from the property. Kuhio, Kalakaua, and Alawai. Economic impacts were disclosed both near-term and short-term in terms of short-term job creation on a 2-year work period, and longer-term in terms of the jobs that would be created during the operational phase. Economic impacts are also disclosed in terms of the GET, TAT, and RPT that would be produced annually.
You're
So-
talking about the 2139 EA though, right? The 2121 didn't disclose impacts related to the other project, correct? Or did it?
The 2139 was more forthcoming. So for 2121, the areas not covered that were covered in 2139 were air, energy, and wind. But for example, the 2139 EA has a graphic image of wind impact that shows the impacts of a no tower development, a Tower 1 only development, and a Tower 1 and 2 development.
What would have changed in the 21-21 EA review if there were, the 2139 address was clearly understood. It's in city documents. What would have changed at that point where the property wasn't owned yet by PACREP? How would the city have approached a disclosure like that? We're in negotiations to possibly purchase the food pantry property.
Okay, so clearly the city would have preferred an upfront disclosure of both projects. In this case, I think what happened was the city looked at the 2139 DEA, and that was the first notice to the city of the possibility of Tower 2. The Tower 1 EA made a good argument about the reasons for orienting the tower of a diamond head. And although they say, well, it's apparent that there's some plan to use a food pantry site. The food pantry site was part of the Tower 1 EA, and that's because it was included in a joint development agreement that allowed that parcel to be developed for Tower 1. The issue is that just because a property is in a joint development for regulatory zoning purposes doesn't mean that the developer has the proprietary right to use that property. And so when PACREP is dealing with negotiating to acquire the property, that's the issue that they're trying to address, is whether or not food pantry will essentially sign off to the sale and use of that property.
There was a redesign once the property was actually, 2139 was actually acquired, is what I understand, right? I mean, it changed what the actual project was going to be once 2139 was actually purchased.
That's correct.
And that affects what the review is.
Well, it changed the project at the permitting stage at that point. The Tower 1 EA proposes, for example, a 5-story podium.
The permitting stage, is that what you?
Correct. The Tower 2 EA proposes a 8-story podium. And so there was some project change in between the EA reviews. And I suppose what we're saying is the Tower 2 EA is really the remedy for any type of segmentation that may have occurred, right? Because when you find segmentation on the EA, you remand for a new EA. And the purpose of that remand is to get disclosure on the secondary and cumulative effects, right? In this case, the Tower 2 EA provided that analysis, right? Local 5 really hasn't pointed to any issues that haven't been thoroughly assessed. So
But in terms of, based on the city's review, DPP's review of everything that was produced during discovery and looking back, and I realize that it's difficult in hindsight, with the knowledge that you had as of the time of the acceptance of the Tower 1 EA, based on the record existing as of then, would DPP have required a joint EA for the two projects together?
if we knew that Tower 2 was coming, then we surely would have. But in terms of, the purpose of this, the remedy, right, which is a new EA to address secondary and cumulative effects, we don't think that this case is suitable for a remedy. The case that Mr. Kugel cites to in terms of cases not being moved or surviving.
What happened in terms of any conditions on the permit as to units being placed, required to be placed in a hotel pool instead of being allowed to be residents? This is Ritz-Carlton residences. From the record seems to indicate that no units have to be included in a hotel pool.
So in terms of what happened with the permitting, that's not part of the record. But I can tell you that there were arguments from the developer that these units would not be marketable and it would not be practical to indicate which specific units could be occupied as residences, which could be occupied as hotels. They represented that all units were hotel units. If anybody has stayed at Aulani, their catchphrase is "welcome home." When you show up for your vacation or your staycation, they say, "welcome home," and they want you to feel like this is your home away from home, right? So in this case, there is some marketing there, and they are saying that these are the Ritz-Carlton residences. What the EAs disclose about use is that most owners will probably stay there 2 to 3 weeks per year and rent them out as hotel units for the rest of the time. It says that based on Trump, 75% of the units there are in a hotel rental pool. That means that they're rented out through the front desk using the hotel system rather than through some other platform or arrangement.
What did you say about the 75%?
I think they disclose that 75% of the units in Trump are part of a hotel rental pool. And so pool just means it's rented out through the hotel itself and not through a third-party arrangement. And so they said that 2121 would see a similar level of use. They said that they expected to see maybe 14 units occupied as more full-time residences. And for Tower 2, they said 5%. I mean, combined, we're looking at roughly 33 potential resident units. And the impact of that on a population of about 31,500 people. So that was not a significant population change or impact to infrastructure. In terms of the ecological effects of hotel versus residential use, at the end of the day, both uses involve the use of a unit for human habitation. So the same things are happening in the bedroom, bathroom, and kitchen. So ecologically speaking, we don't think that that's a huge change. There was ample evidence of adequate school transportation, police infrastructure. And so for the purposes of an EA, which is under Section 10 of the Administrative Rules, really providing information in a general and summary fashion, right, under paragraphs 4, 5, and 6, it says general and summary information. DPP was comfortable with the level of disclosure provided through each and both documents.
Changing subjects. One of the things that Local 5 had argued was insufficient discussion of the no action alternative. But the rules do not seem to require a no action alternative except when you're getting to except when an EIS is required. What is the city's position on that?
You're absolutely correct. Section 17 of the rules requires no action for an EIS, but not an EA. We also note that the only trigger for an EIS is a finding of a significant effect, right? And so short of that finding, there's no need to do no action. So, yeah. So in terms of, the remedies, Mr. Kugel argues the Cantrell case, right? So that's a case where they converted a Navy building into a shipping hub for commercial containers. In that process, they destroyed a habitat for birds. So although that action was fully implemented at the time of the NEPA challenge hitting the appellate court, the court said, we have a practical remedy. We can remand this and you can do further environmental study to see if it's necessary to create a replacement habitat, right? So that was a sensible, practical remedy. The foil to that case is Feldman versus Bomar. That's 518 F3D 637. And that was a pig eradication program. So what happened in that case is by the time the challenge hit the appellate court, the Ninth Circuit, all of the pigs had been eradicated. And so plaintiffs said, well, you could reintroduce pigs. This case is not moot. And the Ninth Circuit said, we will absolutely not do that. The pigs are bad for the environment. That's why we got rid of them. So they said, we don't think you have a practical remedy. We can't resurrect the pigs. We're not going to reintroduce pigs to the environment. There's just no practical remedy. And so in analyzing mootness, what the court looks to both in the Ninth Circuit and under Hawaii law is there an ongoing injury, right, that is capable of remedy? So if the injury in this case is segmentation, it's basically procedural or informational. Further environmental review to assess any particular impact of this case, on that issue, Local 5 has not identified which issues require further study, what the disclosures might produce, and what mitigating conditions could be imposed.
But there was discussion about parking, about access to parks, and the thought was the original 2121 kind of lowballed what the impacts would be, and now that the full scope of the impacts are known, there could be potential mitigation on those subjects, maybe direction to develop more parking or dedicate some park space. I don't know.
I have a two-part response to that. So the first part is, if you look at the definition of acceptance, an acceptance of a 343 document does not mean that the proposed action is environmentally appropriate or that it should be approved. It's only a determination that the documents made a good faith effort to disclose the necessary information. So in this case, it's not really about what happened ultimately. It's about whether the information presented at that time should have opened the door to further permitting and project consideration. The second part of that is factual. So the Tower 1 EA proposes 187 stalls and it reports 160 required. The Tower 2 EA proposes 133 parking stalls and 81 required. So if you add the stalls for Tower 1 and Tower 2, the cumulative effect is disclosed. And so DPP finds that disclosure sufficient. We don't, in terms of permitting, during the permitting process, if the unit count changes through those applications and that review, DPP will impose the appropriate conditions. That's not based on what the EA says. We don't continue to rely on the EA. We rely on the actual application and in terms of existing impact, the actual impacts and uses on the ground rather than the forward-looking prognostications of an EA. So just for example, Tower 2 says we're looking at something like 260 to 280 units, right? And so DPP knows from the disclosure what the range of impacts is. But in terms of how many parking stalls actually have to be required, that's calculated when the discretionary permits come in, and it's double checked when the building permits come in.
So your position is that the Tower 2 EA did everything that's necessary to remedy any possible harm from segmentation with regard to the Tower 1 EA?
That's correct. Our position is that the Tower 2 EA read in conjunction with the Tower 1 EA provided DPP with all of the information that it needed. And I think we have to take note of the standards that DPP has to use in making this evaluation. There's always a context. Context is important both factually and legally. So factually, we're looking at the development of a highly urbanized area in Waikiki that was previously developed and used for hotel uses. It's also occurring in an environment that's used for a mix of hotel, apartment, retail, and restaurant. So that's the context of the development, right? The context of DPP's review is Section 2 of the administrative rules says, in order for a socioeconomic impact to be found significant, it must be adverse, right? So no matter how much beneficial job creation or tax revenue there is, those won't give rise to a significant effect under Section 12. Section 12 of the rules also tells us that in order for socioeconomic impacts to be significant, they must be substantial, right? So the question is, would further review disclose a substantial adverse economic or socioeconomic effect? And DPP didn't think that would be the case. In terms of viewplane impacts, Section 12 also says that viewplane impacts must be substantial. It says the same thing about secondary effects. Secondary effects are significant if they are substantial. And with respect to cumulative effects, it says that those have to be, sorry if I can turn to my notes for a second here, considerable, right? So there are words that tell DPP what level of effect you're looking for. And DPP puts that on the scale in deciding, do I need more information or do I not?
I know your time is up, but real quickly, in the circumstances that we are in, where the property has been substantially sold, we're not exactly sure how much, and is retained by the developer. If you had to do another review, how would that impact the city's ability to do that?
Well, to be perfectly candid, and just to address the issue of unit sales, one tower is 100% sold, and I think the figure was something like 97% sold in the other tower. It's in the declaration from developer attached to PACREP's MSJ. But to be candid, DPP would do its best to do an objective review, but I don't think you can unring the bell, right? A staff planner sitting at the desk can't imagine away a couple of $350 million hotel units. It's going to weigh on their mind, and however they might try, I think it would prejudice the review. I think the same thing would be said of a new 343. Whether it's an EA or an EIS, at this point, I think that document becomes a cesspool of post hoc justifications for the projects that are already built. So in some ways, there's no turning back and really objectively looking at these projects or their environmental effects. If you're asking, should they be approved? Can they continue to exist? I also think that we would be impacting third-party property rights, and that may raise due process concerns.
I know the time is up, but I do have also a follow-up question. PACREP is saying, they didn't have the rights to 2139 until March of 2013. But are EAs ever submitted with alternatives? Like if we get this parcel, this would be the impact. But if we don't get this parcel, we're going to do it this way, and this would be the impact.
And I guess I'd answer that question in a couple of ways. The first one is to say, in my experience, I have not seen that. But I do agree that, 343 says to present a range of alternatives and to consider them. And so whether or not that ought to be the practice, there's an argument to be made there. But I would say at the end of the day for DPP, when we look at things like this, we don't know what's in the back of office files of a developer, right? We don't know their subjective plans or their intentions. And so at the end of the day, what we're really looking at is the quality of the disclosure, right? Somebody acting with the worst intent, the most pernicious intent, if they give us something that honestly discloses the impacts of the projects, we can move forward in our permitting decisions, right? If we spend our time speculating on what the real agenda might be, we're not in a good position to do that, right? I mean, we only know these things now in this case because there was litigation, there was discovery, and I think there's still a fair argument on both sides about what the agenda was and why things unfolded the way they did. So from DPP's perspective, we need to just stay in the middle and focus on the quality of the disclosures, rather than some of these outside things that are beyond their control.
Anything further, Mr. Saito?
Nothing further, thank you.
Okay, thank you very much. Mr. Kugel, your rebuttal. At this point, I'd ask you keep it to less than 5 minutes, if you could.
Yes, Your Honor. I will use this time just to summarize, and thank you. I will be brief. I think the end result is you have both the city and PACREP telling you there's nothing you can do here. And I frankly don't think that given this court's prior HEPA cases, that it ever envisioned HEPA would be toothless under these circumstances. And these circumstances are important. You do have the 4 emails that predated the submission of EA number 1 and then followed it, saying, keep this secret, don't tell Keith, keep this secret, don't tell anyone. I think there are risks if we write this down. Those are the smoking gun emails. And so under those circumstances, I'd have a hard time sitting in your shoes to say that they should be rewarded for that. You heard the city say, we only know what the developer tells us. I mean, this is the case that you didn't have in Kia'iwai. This is the case where there is some evidence, perhaps there could be more. That is true. I think it was sufficient. I felt it was sufficient when we filed the summary judgment motions in 2016 and then supplemented them with discovery to show that there was segmentation as a matter of law. And I argue that same point today. I think that another comment that the city made is one that really goes to the dichotomy here. You heard PACREP argue, boy, what has to happen under Hawaii law is you need to consider things at the earliest possible time. So if we're negotiating for parcel number 2, we're already signing agreements, made an offer, hasn't been accepted, but we're developing number 1 and we're including in our plans, which is our secret, that we're gonna jointly develop both when we can get there, I think that matters. Wade, on the other hand, you have the concerns which falls exactly into what the city is arguing. And I just pulled the quote from this court's decision in 1999, a HEPA case, again, Citizens for the Protection of North Kohala Coastline, 91 Hawaii at 105, when this court explained the problem with segmentation. Quote, the rationale behind this rule is that inflexibility may occur if delay in preparing the EIS is allowed. After major investment of both time and money, it is likely that more environmental harm will be tolerated. And to use my words, in other words, subsequent decisions and approvals, in this case, EA number 2, become a fait accompli. It's a done deal. The city has argued that, well, we took a second hard look at things, and yes, we were hoodwinked before, but we looked at all the impacts now, and there just is no remedy here. And I suggest that is not what the legislature thought that HEPA should be. That's not what your prior cases suggest. And I think that
What's your answer to Mr. Saito's argument that the EA for 2139 is the remedy, that covered all the possible impacts with the full understanding what the project would be?
Well, I think it's still is subject to exactly what this court said in North Kohala, Citizens to Protect North Kohala, which is at that time, the city was sort of already pregnant with this problem. They had already approved it, and it was a self-fulfilling prophecy that they come back again and say, oh, okay, now that you told us you're gonna combine these two things on a shared podium with shared amenities, shared recreation, shared access, shared parking, it's twice as big as we thought it was. Well, we looked at it and there's no greater impacts, and we can't do anything about those impacts. It became a self-fulfilling prophecy, and I don't think that this court should walk away from this case and say, yeah, under the circumstances of this case, there's no remedy, it was cured, and that's the end of story, and that's when NEPA dies, or HEPA dies.
Mr. Kugel, we're up at about 5 minutes. Anything further for the court at this time?
I have nothing further. I appreciate all of your questions. I know that this court has read things at least as thoroughly as the lawyers, and I thank you for your time.
All right. Thank you to our attorneys today. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'oku ia mai nei ki ia aha ho'okolo ki e hano hano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.